Based and primarily used registration. Hello yet again. This is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Finally, let's discuss the registration pathway that is often mentioned but frequently oversimplified, the based and primarily used rule. The pathway is grounded in 49 U.S.C. section 44102 and implemented in 14 C.F.R. section 47.9. And the first correction to make is an important one. This is not a broad registration option for any non-U.S. person. It applies to a corporation that is not a U.S. citizen, but is organized and doing business under the laws of the United States or a state, with an aircraft that is based and primarily used in the United States. This limitation matters. If the ownership profile does not fit the statute, this pathway does not fit the transaction. Under Section 47.9, the corporation must submit a certified copy of its certificate of incorporation, a certification that is lawfully qualified to do business in one or more state, a certification that the aircraft was based and primarily used in the United States, and the location where the required flight records will be maintained. There is also a 60% test. It's more technical than many operators realize. For FAA registration purposes, the aircraft is based and primarily used in the United States if the flight hours accumulated within the United States account for at least 60% of the total flight hours during the remainder of the registration month and following 6 calendar months, and during each 6 calendar month period after that. So there's reporting requirements every 6 months. And the rule does not count every U.S. connected flight the same way. Under Section 47.9c, only flight hours accumulated during nonstop flights between 2 points in the United States count as flight hours accumulated within the United States, except for emergency or refueling stops. That is a much narrower definition than many people assume or realize. In addition, the corporation must maintain those records and make them available for FAA inspection upon request. And the records must be kept for 3 calendar years after the year in which the flight hours were accumulated. That is why I often advise clients that based and primarily used registration is not a filing strategy. It is actually an operating discipline. If the aircraft's mission shifts towards international activity, the structure can quietly drift out of compliance. And under 14 C.F.R. section 47.41, when the applicable period described in section 47.9b ends and the aircraft was not based and primarily used in the United States during that period, the certificate becomes ineffective. That is not a technical nuance. That is a real registration event. Operationally, this can affect much more than the registry file. It can raise issues for lenders, insurance, counterparties, and any transaction that assumes valid and continuous registration status. This is also a broader regulatory backdrop. U.S. registration does not itself solve economic authority issues, charter issues, or cabotage issues. Operators still need to analyze how the aircraft is being used, by whom, and for what kind of compensation or business purpose under the applicable FAA and DOT framework. So, yes, based and primarily used, that pathway can be effective, but it works best for aircraft with a genuinely stable U.S.-centric operating profile. Disciplined flight hour tracking and management teams that understand the rule is measured continuously and not casually. I hope this point sticks. This pathway for based and primarily used registration is not self-executing. Every flight hour is a vote. If the aircraft consistently flies the right profile, the structure holds. If the profile changes, the registration risk changes with it. In many international ownership scenarios, the ongoing operational rigidity is exactly why parties prefer owner trusts instead. The owner trust often provides more flexibility, while the based and primarily used pathway demands operational consistency. My closing thought is this: the right registration structure is not the one that works on signing day. It is the one that still works after financing, after the management agreement, after the itinerary changes, and after the FAA asks for the file. Thank you for your time and interest in this topic. This information is provided for informational purposes only, and it should not be construed as legal advice. Questions are absolutely welcome. Please direct them to admin@aviationlegalcounsel.com. We look forward to helping you navigate these questions and issues with precision.